Hello, everyone. My name is Greg Strong. I'm at DLx Law. We are a boutique law firm in the United States, and we engage primarily around blockchain and crypto-related legal issues with our clients. I wanted to thank Jin and the Hash team for having me here, and it's been great to hear from the other speakers so far. So I'm going to cover the U.S. regulatory landscape. And I'm pleased to tell you that it's pretty straightforward. So this is kind of what our payment clearing and settlement systems regulatory infrastructure looks like. And this obviously relates to like the traditional financial world. And so all we're doing now in the United States is trying to map this onto digital assets and crypto. So it's very easy. But in all seriousness, I wanted to walk through some of the players here that are on this chart. And I'm going to start in the middle with the SEC. So the SEC in the United States obviously regulates securities. And one of the threshold issues that we will talk about a little bit more in this presentation is, sort of what is the nature of a crypto asset, and when do transactions that involve crypto assets trigger securities law compliance obligations? That is a key question because it really depends whether you're in the middle here or whether you might come over here. And then maybe you might be up in the upper left-hand corner, which is actually incomplete because it doesn't address money transmission and money services business obligations. So moving over to the CFTC is our commodities regulator. They do not, in general, have spot commodities authority. So spot commodities markets are generally unregulated unless there's an allegation of manipulation or fraud. And then they would have the authority to regulate. And so unlike the SEC that has broad sort of surveillance authority over securities markets, the CFTC does not have surveillance over spot commodities markets. Where they do get involved is with respect to derivatives, as Commissioner Pham pointed out. And so futures, swaps, options that have an underlying commodity are all regulated by the CFTC. I mentioned sort of up in the upper left-hand corner there, we've got a reference to the Federal Reserve Bank, and related to that would be sort of the Treasury Department. The Treasury Department has two branches that are important. One is called FinCEN, so the Financial Crimes Enforcement Network, and FinCEN oversees money services businesses, and if your activities put you within the definition of a money services business, then you have an obligation to register, which you can do in about 30 minutes on their website. It's very easy. And then you have to comply with the Bank Secrecy Act, which is much more complicated. So it requires policies and procedures, know your customer, identification, and suspicious activity reporting. Lots of different obligations get triggered when you are engaging in those activities that give rise to an obligation to register. The other side of Treasury would be OFAC. OFAC is responsible for enforcing sanctions compliance. And so that means engaging in commercial transactions with any sort of person or entity that is subject to a sanctions program administered by OFAC. So there's something called the SDN list, specially designated nationals, which is a list of people and wallet addresses and smart contract addresses now that US persons are prohibited from engaging with for commercial purposes. And so we're going to talk a little bit about Tornado Cash at the end, because the Tornado Cash wallet addresses and smart contracts are on the SDN list. This chart deals with federal regulators. And as many of you may know, in the United States, we have a federal regulatory regime, and then we have 50 states and some other territories and jurisdictions. They also have their own securities regulators at the state level, and their own money services business regulators, and there's a licensing regime for money transmission activities at the state level. So we'll talk a little bit about that in a moment. So I want to come back to sort of the threshold question that really determines sort of where you fall on that chart in terms of how you are regulated in the US. And that relates to the securities law analysis of a digital asset or activities that involve digital assets. So how many people are familiar with the Howey Test? Okay, lots of hands. How many people are sick of hearing about the Howey Test? All right, lots of hands. So some people aren't sick of it yet, so I'll go through it quickly. But it really is sort of the test that determines, are you going to be regulated as a security, or are you going to be regulated as a commodity or something else? And so the US securities laws require securities to be registered or exempt from registration. And the definition of a security in our law includes stocks, bonds, notes, a whole bunch of other types of items, most of which you would look at and you would say, okay, this is familiar to me, it looks like a securities product. And then on that list of enumerated items within the definition is something called an investment contract. And that is really sort of a catch-all for all sorts of different schemes that are designed to sort of part an investor with their money in search of profit. And so it's a flexible test, that's the way it's designed, and it's also very facts and circumstances specific. And so the test has 4 parts, and so if a transaction, contract, or scheme involves an investment of money in a common enterprise with an expectation of profit to be derived primarily from the efforts of others, then you have an investment contract and you have a security and you are subject to securities laws. And so the import of that is that once you're in this securities law framework, there are obligations to register if you're acting as an intermediary with respect to these types of assets. So broker-dealer registration, exchange registration, registration as a clearing and settlement firm, lots of different things can flow from that. If you have trouble sleeping, there's a link to a paper that myself and my colleagues wrote about the application of the Howey Test to digital assets. So you should check it out. I guess the position that we take in that paper, which I think is really important to consider, and the SEC does not necessarily agree with this, but our position is the crypto asset itself should never be treated as a security. The Howey Test contemplates almost anything in the world can be able to be sold as a security, depending on how it's marketed to the purchaser, what expectations are created in the purchaser's mind, and ultimately, like, what is the intent of the purchaser when they enter into that transaction. So that was true in the Howey case, which involved orange groves and contractual arrangements around the orange groves. That was true in other cases involving all sorts of weird stuff like chinchillas and whiskey and everything else. That is the test they applied to digital assets, but our position is that the digital assets themselves are no more securities than the orange or the whiskey or the chinchillas. And so that test really needs to be applied every time there's a transaction involving a digital asset in our position. There are some links here to some of the key regulatory guidance and enforcement actions from the SEC. I'm going to skip over those because we don't have time to get into them. But I do want to talk about a couple of the cases that are sort of ongoing at the moment. The first is Ripple Labs, and so there was a motion for summary judgment filed in the Ripple Labs case, cross motions for summary judgment, actually. And the judge in the Ripple Labs case applied the Howey Test to 3 different means of allocating the XRP token out into the world. The first means was the sale of that token to sophisticated purchasers, institutional purchasers. The judge found, applying Howey, that the elements were met, that those transactions are securities transactions. The second was programmatic sales through exchanges where the purchasers did not know that they were interacting with Ripple Labs on the other side. The judge found no expectation of profit from the managerial efforts of Ripple Labs, therefore no securities transaction. And the third one related to allocations of XRP to employees and other developers. And again, the judge found that there was no expectation of profit there, and so no investment contract. That's a very good result because it shows two things. First, the judge is looking at each means of allocating the token and applying the Howey test to each one of those means and saying, the token isn't the security here, but if you sell it in this way to these groups of people, it's a securities transaction. And if you do it in these other ways, it's not a securities transaction. So what we have here is XRP, the same token being sold in a different manner to different people or allocated in a different manner to different people and getting two different results, which is consistent with the facts and circumstances analysis required by the Howey test. That's going to be really important for some of these other cases that are going on, Coinbase, Binance, and Bittrex. Those cases are a little bit different than Ripple, Terraform, Library, because they involve secondary transactions in these assets. So those other cases involve the initial allocations. And some of those initial allocations involve capital raising. And as Commissioner Pham pointed out in her remarks at the beginning, when you're selling something for a capital raising purpose so that you can fund a business, that's probably a securities transaction under US securities laws. The question is, what happens when the token is being traded in a secondary transaction where the parties to the transaction have no privity to the initial sponsor and where that transaction is happening on a completely independent platform? And we will get an answer to those questions, hopefully, in one of those three cases. I wanted to touch on recent FinCEN guidance, which is actually not that recent, but it's from 2019. So FinCEN, as I said, regulates money services businesses, and there's a registration requirement, and then also compliance with the Bank Secrecy Act. There is a state-level money transmission licensing regime. I'm going backwards now. I'm not sure how I did that. All right. Thank you. So Tornado Cash is sort of the most recent example of FinCEN applying their existing law to a protocol composed of smart contracts and two individuals who were providing services around that protocol. And those individuals were charged with committing three different crimes: conspiracy to commit money laundering, conspiracy to operate an unregistered money transmission business, and then also conspiracy to violate IEPA, which is a sanctions regime. And so this case really sort of highlights something that I think has been discussed generally amongst all of the panelists, which is, at what point in time do the regulations apply? Especially when what we're thinking about is, at its core, code deployed to a blockchain that is never going to leave unless the blockchain shuts down itself, and that is going to be publicly accessible forever. And I think the answer to that question, whether it's in the securities law context, the money transmission context, or the CFTC context, is looking at what the people around that protocol are doing and what level of control they have with respect to how that protocol is actually operating. So looking at things like the front end and who is hosting the front end and providing user-friendly access. Looking at things like technical sort of components that may be outside of the core smart contracts, like relayers, and other technical aspects that are facilitating the transactions that are involved, and things like that, and also like where are fees being directed and who is benefiting financially. So I think that's what this case is about. There's a lot more to say, but we're running out of time. We've mentioned the state money transmission licensing regimes, and that's me. You can skip that one. But anyway, it was a pleasure speaking with you all. I'll be around to talk more about this, and thank you very much, Jen.